Everyone. I'm Lissy Medvedow, Executive Director of the Rappaport Center for Law and Public Policy, along with my colleagues, Professor Dan Kanstrom, Faculty Director, and Cindy Wynn. We welcome you to the community address for our Senior Fellow, John Miller. Last year, we launched a new initiative to bring Senior Fellows, mid-career professionals who are doing cutting-edge and important work to BC Law School to engage with our community. We're providing opportunities for the Senior Fellows to meet with students, faculty, staff, as well as our public service, public interest community. So far, so good. To introduce our Senior Fellow, we've asked one of our prior Rappaport Fellows, Christopher Phipps, to do the honors. Chris is a 3L here at BC Law and one of our newly elected executive editors of the Uniform Commercial Code Digest. During his Rappaport summer, Chris worked as our first ever intern at the Office of the Massachusetts Inspector General. Chris is a graduate of Temple University, where he double majored in political science and strategic communication with a focus in rhetoric and public advocacy. Before law school, he worked as a policy director for Pennsylvania State Representative Joanna McClinton. He is a do-gooder. Before I turn the program over to Chris, I want to invite everyone to next Monday's program, also at 4 p.m., entitled Equity Gaps in Education, What Now? We have an incredible panel that includes a Boston Public School teacher, the superintendent of the Medford Public Schools, and the president of the Spencer Foundation. Our moderator is Professor Rebecca Levine Coley of the Lynch School of Education and a member of the Rappaport Center Advisory Board. I hope you'll join us for that as well. Please note that today's program is being recorded, and during the Q&A, which we'll reserve about 15 minutes at the end to hold, feel free to write out your questions or use the raise hand function if you'd like to ask your question aloud, and we'll unmute you as long as time permits. It's my pleasure to now introduce Chris Phipps.
Thank you, Lissy, for the gracious introduction. It is my honor to introduce the Rappaport Center's 2021 Senior Fellow, Jonathan Miller. A champion for the underserved, John has devoted his talents and career to standing up for marginalized communities. Presently, as the legal director of the Public Rights Project, a nonprofit advocacy organization that collaborates with government agencies and community organizations to expand legal access to historically disenfranchised communities. John oversees partnerships with over 60 state and local government offices, legal fellowship programs, and advocates for communities through litigation, amicus brief, and strategic engagement. Prior to the Public Rights Project, John served the people of Massachusetts in the Office of the Attorney General. First as an Assistant Attorney General and later Chief of the Civil Rights Division, John helped lead a successful challenge to the Defense of Marriage Act and helped secure $100 million in consumer relief against a subprime lender following the 2008 financial crisis. John has also served as Chief of the Public Protection and Advocacy Bureau, leading initiatives in the areas of civil rights, consumer protection, and worker rights. There, he helped lead several challenges to Trump administration policies, including travel bans, DACA termination, and restrictive contraceptive policies, among many others. John is an alumnus of Dartmouth College and Columbia Law School and has taught courses at Harvard Law School, Northeastern School of Law, and Suffolk Law School. John joins the Rappaport Center today to speak on equitable enforcement in the existing case selection model used by prosecutors. With that, it's my honor to welcome Jonathan Miller, 2021 Rappaport Senior Fellow.
Thanks so much, Chris. Thank you for that very kind and generous introduction. And Lissy, thanks for convening us all here today into the Rappaport Center. I'm really honored to be a part of this program. I've had the opportunity to engage with some faculty at BC already, and I really appreciate the opportunity to be here with all of you today. And with that, I think we'll get started. So I want to begin by acknowledging the events of last week. The violent murder of 8 people, including 6 women of Asian descent, in the Atlanta area is a hate crime. It's part of a lengthy history of violence, discrimination, and misogyny against AAPI people in this country, dating back at least as far as the Chinese massacre in Los Angeles in 1871 and the Page Act of 1875. It's a horrifying reminder of the daily epidemic of gun violence in America, and it's connected to the racial scapegoating of AAPI people for the COVID-19 pandemic, resulting in a rapid increase in bias, discrimination, and hate crimes over the past year. Together, we must all do work to dismantle the affliction of white supremacy and to tear down structures that perpetuate systemic racism in the United States. My humble hope is that today's talk helps to promote more conversations and advance that urgent work in at least some small ways. I'm a professional product of the complaint-based system. For more than a decade, I worked as a lawyer in the Massachusetts Attorney General's office. I spent much of my time reviewing, evaluating, and digging into complaints from constituents. Complaints about landlords, complaints about retailers, police officers, and restaurants. Individual residents called upon our office to intervene in eviction proceedings when their wages were not paid and when businesses were charged surprise fees. The complaints were the lifeblood of our work. They spurred us to action and informed so much of our litigation and enforcement dockets. One complaint from early in my career resulted in a particularly memorable case. A resident of Norwood called seeking our assistance because his neighbor was harassing him. She physically confronted him, she called the police on him, she bullied him, all because he was gay. We filed a lawsuit against the neighbor and obtained a civil rights injunction. The neighbor moved out, and our complainant's life was changed immediately for the better. It's a case that stays with me to this day, and it's all from a single complaint. This is not a unique example. I could probably use this entire time to highlight complaint-driven action that resulted in real and meaningful relief to constituents. The complaint of a motorcycle owner about his insurance led to millions of dollars of relief for thousands of consumers, all from a single complaint. I spent the formative decade of my legal career developing cases, advocacy, and approaches on the backs of constituent complaints. An operative question in most of these cases was, have you received any complaints about this? I'm here to tell you today that we're doing it wrong. The heavy reliance on who calls, what they call about, and the evaluation by staff deploys the enforcement machinery of these offices in a way that reinforces rather than disrupts inequality and inequity. The Public Rights Project, we call this the squeaky wheel problem of complaint-based enforcement. Those who have the wherewithal to complain get attention, get the power and force of government authority behind them. It perpetuates systemic racism. The genesis of my critical perspective of the complaint-based method arose from another case from early in my career. This was one against a subprime mortgage lender, Option 1. Many consumers called and complained about their Option 1 loans, especially as they fell behind and were unable to pay the rising monthly bills due to exploding adjustable interest rates. Among other things, I was charged with helping our team to develop a claim under the state's anti-discrimination law. We'd alleged that Option 1, through its use of discretionary pricing, was charging Black and Latino borrowers more for their loans, irrespective of their risk profile. Often the disparity was hundreds of dollars. No one, or almost no one, was complaining about this particular problem. We can and should unpack the reasons for that. But crucially, the borrowers likely would not have known that they suffered discrimination. They might have known they had a bad loan. They would not have been able to compare their loan terms to a similarly situated white borrower, nor show a pattern across hundreds or thousands of loans. It took our power of investigation and evaluation across all loans to see the pattern of discrimination and the driver of disparities. And these disparities in pricing were among the factors that caused borrowers of color to lose household wealth disproportionately during the subprime crisis. To sum it up, this was a broad problem affecting communities of color significantly, which did not produce complaints to the office. It's the type of thing that we miss all the time. My work on discriminatory lending piqued my interest in the connection between discretionary decision-making and racial bias. As it turns out, it's the broad discretion involved in the review and evaluation within the complaint-based system that likewise drives many of its flaws. Our government must be set up to hear from constituents and respond to their concerns. There's vital importance in the use of personal narrative to drive a commitment to work for change. People feel more compelled to solve problems when they are connected to those who are affected by their problems. My concern is not the existence of the complaint-based process, but that it's playing an outsized role in directing government activity. We need to be aware of these clear and dramatic consequences. We need to recognize flaws in our current system to emphasize what is good and important, and to push against the bias, the discrimination, and the perpetuation of systemic inequalities. My talk today is going to consist of 4 parts. First, I will explain in a bit more detail how central the complaint-based system is to the work of enforcement agencies. Second, I'll walk through the bias infecting both the inputs and evaluations of complaints throughout the process of intake review. Third, I'll explain some of the relevant legal frameworks, both uplifting civil rights concepts that might challenge the system and cautioning about the ability to remediate given the current composition of the US Supreme Court. Fourth, I will explore some methodologies, both from in and out of government, to combat these biases and flaws in the process. I want to begin with a brief overview of the complaint-based system to ensure common understanding. There is, of course, wide variation across governments in how these systems function. There's no universal process. But generally speaking, what we're discussing today is a resident-initiated process where an individual can call, email, write, or connect through the internet to a government office to raise a concern about a specific issue. This could be the conditions in their apartment, the terms of the loan that they received from a car dealership, or their treatment at a restaurant. It's an individualized process in which a person comes forward and complains about something that's happened, usually to them, though not always. Coming forward is the first step. From there, the agency takes over. Again, there'll be wide variation from office to office, depending on their role, resources, authority, and political will. Some offices will take in many complaints, but rarely respond to them. Others seek to respond in some way to every complaint. Others have an obligation to investigate based on their statutory role and have routinized processes for investigation and review. There are a few key steps on the agency side I want to highlight here because they're relevant to our overall analysis. Those steps are review, mediation, and escalation. The review takes place in 2 stages. After the complaint is filed or submitted, it needs to be processed. This is typically a cursory review of the information that's come in. What's the issue? Has the agency received the information it needs? Some agencies, there might also be a question about which department it should go to. Decisions are made early on about what is and can be handled. Some complaints are also fast-tracked for more serious consideration by escalating them immediately. Once processed, the complaint goes into a queue to be reviewed and evaluated. This is a more detailed process. The staffer takes a look at the information submitted. Sometimes this is a written narrative. There may be a form that's completed. There might also be documents attached and other materials. In certain situations, the staff member will reach out directly to the individual, usually called the complainant, to gather more information, to hear what the person is seeking, to make sure the problem still persists. All the while, the agency team member is evaluating. Based on her experience at the agency, her training, what the law permits, and her perspective, she'll ask, is this something that the agency should handle? Is this complaint credible? Assuming that the process continues from there, this team member might reach out to the business, the landlord, or the employer to gather additional information. In many situations, there's an effort to try to mediate a resolution. Will the dealership take back the car? Will the employer pay the wages? All the while, the staffer is making a bunch of discretionary decisions. How hard to push for an outcome? How much time to spend on the complaint? Whether to write a letter on office letterhead. It might resolve through mediation. It may go nowhere, or it might continue to enforcement. Some complaints seem so egregious from the outset that they're put into an enforcement posture from the start. That's to say, they're passed along to an investigator or another staff person who digs in for the purpose of enforcement rather than review and mediation. Others wind their way to this point. The violation may seem relatively clear, the entity on the other side may be difficult, or have a track record of bad conduct. Based on a variety of factors and priorities, the agency moves from review and evaluation to enforcement. And now there's a new perspective on handling the complaint. An inspection of the premises may occur, documents might be subpoenaed, other witnesses spoken to. The case gets worked up. Eventually, it may go to litigation or some administrative process, all of which can arise from a single complaint. Complaint systems are highly prevalent across our governments in the United States. A simple search of the term complaint on state websites frequently reveals dozens or more unique places to submit complaints or types of complaints that agencies will receive. Searches in Arizona, California, and Georgia revealed more than 20 different results without further inquiry. Arizona's website lists a range of topics for a complaint, from the Board of Podiatry to the Department of Housing and the Registrar of Contractors. And that's just at the state level. The city of Phoenix offers guidance on filing language access, discrimination, noise, police, wall, or fence complaints. What's striking is not just how many different ways people can complain to their government, it's that these complaints are such a strong driver of enforcement. I've known this fact to be the case for a while based on my experience in the Attorney General's office and my discussion with partner offices. I gained further perspective over the past year plus while working a public rights project. To solidify this understanding, I conducted a survey of partner government enforcement agencies earlier this year. From that survey, I received 50 responses. Survey results indicated that 92% of respondents listed constituent complaints as a source of enforcement actions. This same survey revealed that 68% of respondents utilized at least one complaint mechanism as a top 2 source of enforcement. Many of these government partners also relied heavily on referrals from other government agencies who are also using complaint systems, thus further reinforcing the outsized use of complaints. In some deeper dive interviews, respondents revealed that certain offices are more responsive to complaints than others, but a complaint-initiated process that can lead to enforcement is the norm for virtually all the government agencies with whom we spoke. Every stage of the complaint-based process is marred by bias. Let's begin this part of the discussion with a review of the inputs into the system. A number of studies have revealed extensive disparities in who calls and files complaints with government. A study from 2017, for example, closely examined 311 calls to the city of New York. The study out of NYU focused on complaints relating to lack of heat or hot water in buildings throughout the city. The study utilized methods of predictive modeling to reach some important conclusions. Neighborhoods with a lower than predicted rate of 311 calls have a higher proportion of male residents, of an unmarried population, and a minority population, a higher unemployment rate, and more limited English speakers. Based on these results, the researchers found that socioeconomic status, household characteristics, and language proficiency have a significant effect on the propensity to use 311 across the city. These same researchers examined complaints about potholes and pothole repairs in Kansas City and reached similar conclusions in a report published earlier this year. In neighborhoods where potholes were underreported, the population is nearly 60% Black, more than a quarter of the households live in poverty, and the median income is around $35,000 per year. In neighborhoods where potholes are overreported, the population is more than 80% white, less than 8% live in poverty, and the median income is more than doubled at $75,000 per year. Let's talk a bit more about what may be driving these differences. First and foremost, there's deep distrust of government and law enforcement. Communities of color have suffered a long history of abuse, violence, and discrimination by government. That long history and continued lived experience impacts in a real way an individual's willingness to enlist the government to be a partner in action. For immigrant communities, fear, in addition to distrust, can be a real barrier as well. Access is another. Lack of access to the internet or information about government services, language barriers, lack of English proficiency, and cultural impediments to connecting with government will also drive down complaints from certain parts of our communities. Some people also experience a great deal of challenge in finding the right places to go. As noted before, there are a lot of complaint portals. Many residents experience government bureaucracy fatigue, repeatedly being told they need to complain elsewhere. Many people, especially those who've been taught to question their value or worth by our society, have doubts about and minimize their own experiences. They do not come forward because they think they won't be believed, that they think it's not a big deal what's happened to them, or they're better off keeping things as they are. Individuals also feel social and economic pressure not to complain. Matthew Desmond, the Pulitzer Prize-winning author of Evicted, detailed these pressures that many tenants feel not to complain about often unsafe and unsanitary conditions. They are vulnerable to eviction, find paying the rent can be precarious from month to month. Part of the tacit agreement they make with their landlords is not to complain about conditions with the hope that they will get flexibility on rent. Workers, especially low-wage workers, experience similar pressures as a result of their vulnerability. And though laws are designed to protect against retaliation, those protections are not guaranteed and they can be difficult to enforce. The reality is that even when complaints are investigated by government agencies, retaliation can happen, and sometimes without consequences. Disparities in the complaint pipeline create a significant enforcement gap. In 2019, PRP commissioned a study of 2,000 US residents. This was work led by our policy director, Jenny Montoya Tanzi. 54% of all respondents to the survey reported suffering some type of corporate abuse, whether that was consumer fraud, wage theft, or another harm. This group consisted disproportionately of women and people of color. 4 out of 5 of them said that they had suffered more than one form of corporate abuse. However, only a third of them reported any of these violations to government enforcers. Next, we move on to the evaluation stage of the process. Having identified stark disparities in the inputs into the system, we'll highlight some biases affecting the review process. The analysis of complaints reveals several layers of bias that further skews inputs that were already stilted disproportionately. Now, I'm not a psychologist by training and have only delved enough to spot some issues. Experts such as Mazrin Banaji and Jennifer Eberhardt have much deeper insights and a wealth of research to apply. My goal in these next couple of minutes is to impress upon you how flawed by cognitive bias this process truly is. Let's start with anchoring. This cognitive bias causes us all to place too much importance on the information initially provided. How a complaint is viewed is often framed based on the initial information. Does the story make sense? Is it complete? That initial judgment can lock in based on very preliminary information. It can impact what pile the complaint goes into and how it is treated moving forward. Availability bias causes us to overemphasize information that's available to us as we make decisions. The news, other forms of media, and our lived experiences in the world around us impacts how we think about problems and issues. Certain types of issues or complaints may make more sense, quote unquote, or seem more plausible based on the context of the information around the staffer. This bias tends to privilege the dominant culture. Outcome bias can be relevant both for individual and organizational decisions. We tend to think about situations based on how they turn out or about how similar situations turned out before. As a result, we'll tend to overvalue prior experiences in our decision making. That means supervisors who are promoted from a staff level are highly likely to encourage their direct reports to evaluate situations just as they had. I know that's something I did. This can create organizational stasis in the types of complaints that are valued and how they're approached. Outcome bias can also create perverse incentives in the process. Responsible actors and repeat players may be more willing to engage and provide some type of relief through the government mediation. Worse actors don't respond. They can be difficult, obstreperous, sometimes hostile. This tactic can be effective in shying those reviewing complaints away from problematic actors and towards compliance-focused and upstanding entities. Really the opposite of what should happen. Confirmation bias causes us to find evidence that supports what we already believe. Those reviewing complaints will make assumptions about the information provided and fill in gaps based on those assumptions. Ostrich effect may also cause us to ignore negative or contrary information. And most significantly is implicit bias, our automatic preferences based on race, sexual orientation, gender, religion, and other characteristics affects how we perceive, analyze, and react to information. These mind bugs are influencing decision-making processes all of the time. An example of how this plays out in office operations comes from a 2015 study of email responses to inquiries to election officials about voter identification laws. Researchers from Harvard studied response rates and information provided in response to inquiries over 48 states. They found that responses didn't really vary based on partisan lines or demographics of the community, but individuals with Latino-sounding names were at least 5% less likely to receive a response of any kind, controlling for a variety of other factors. The researchers concluded from the data that implicit bias had drove this substantial variation in response to a rudimentary inquiry. What's particularly interesting about this study is that the impact of compliance obligations on bias disruption. The disparity that they found didn't exist in jurisdictions that were then covered by Section 5 of the Voting Rights Act, a law that previously gave the Department of Justice pre-clearance oversight, but which was subsequently overturned by the US Supreme Court in Shelby County versus Holder. Other components of the evaluation process further the skew. Language use, logic of information presented, and completeness of information provided all impact how a complaint is reviewed and analyzed. Complaints that are written clearly, succinctly, and completely are more easily reviewed, they get more attention. But not all complainants will have the same facility with the law, the English language, or government processes. Administrative burden, incentive structures, and even some learned helplessness within government bureaucracy can also sway the process. There's not a lot of reward for helping lots of people. On the other hand, there are swift penalties for being too slow and taking up too much time with your complaints and cases. Workload, in fact, is pretty central to this conversation. Many staff have to juggle high caseloads and are often praised for being able to take on lots of matters at once. A study out of Denmark concluded that race-based discrimination by government officials is exaggerated by a higher workload. As these researchers found, a higher objective workload will affect the cognitive load on the agency staff. As a result, staff use shortcuts to make decisions about prioritization, which causes unintentional and implicit use of stereotypes to be more likely to take place. Finally, bias in the legal system impacts how complaints are handled, analyzed, and resolved. These differences can create invisible or implied burdens of proof, especially in issues like discrimination, which place too high of a demand on complainants to overcome. The perception may be that it's just too unfair to tarnish a business with the label of discrimination absent compelling proof. Structural challenges also impact the process. Arbitration clauses, and other private rules and arrangements may dissuade people from coming forward in the first place, or make companies more emboldened in their responses. Now, having picked apart the discrimination involved in major steps of the complaint initiation and response process, I want to cover one additional point. While we've talked about each complaint as a series of individual decisions, both by the complainant and the agency staff, we must also examine this through a systems lens. This is a highly discretionary system, and from the study and analysis of many other discretionary systems, we know that unchecked discretion leads to disparities overall as well. It's not just about any particular decision, which may or may not be justified, but about decisions in the aggregate. There's no definitive studies of enforcement actions brought by government agencies along these lines, but research of criminal prosecutors and their enforcement decisions reveal similar patterns. An examination of 1 million arrests and federal charges showed significant disparities in whether to proceed based on the complexity of the cases. For example, immigration violations are more likely to be pursued because those cases are about documentation. Studies when it comes to housing code and public health enforcement reveal some similar discrepancies. Summing up this second section, we see how numerous biases compound at every step of the process, which results in the complaint-based system serving to perpetuate systemic racism and act as an instrument rather than as a means of ensuring government responsiveness to the communities whose support is most needed. Before we segue into discussion about some potential interventions, I want to talk about the law for a few minutes. I want to do so for 3 reasons. Because current law is inadequate, because certain civil rights concepts focused on the individual's experience are informative, and because we need to be careful about the approach to corrective action. So does the complaint-based system violate the Constitution? The disparities are clear, but current law does not make this type of bias practice clearly illegal. To start out, discretionary decisions about enforcement typically are not reviewable by courts. Federal courts have long privileged the discretion of prosecutors, including almost complete immunity from civil rights laws. Under court-made law dating back to 1976, prosecutors performing core prosecutorial functions are entitled to absolute immunity from suit. With a deeper data analysis, we could likely show a disparity of impacts through the discretionary decision-making process. But disparity in and of itself is not a violation of the US Constitution under the 14th Amendment for race or other protected categories. Additionally, though federal laws are only beginning to recognize that unconscious bias can lead to discriminatory outcomes, it's happening with great inconsistency. In some instances, in fact, courts have used the existence of cognitive bias to conclude that the discrimination at issue is in fact unintentional. Concepts from other areas of civil rights law can inform our advocacy moving forward, especially when the burden is shifted and the focus is placed more holistically on the individual's experience and interaction with the program. The Americans with Disabilities Act prohibits the exclusion of individuals with disabilities from governmental programs and activities. When examining the design of systems or programs, courts don't focus on whether the exclusion was intentional. Tests involve the connection between the person and the program, the ways in which the system design renders them excluded or impaired in their participation, and the reasonableness of making changes. Now, this is an imperfect solution because the burden on agencies to make significant changes can be challenging barriers for advocates to overcome in an ADA case. But it is a paradigm shift. The question is whether one's interaction with a program on account of a disability is markedly different. This requires the court to understand the experience all along the way from the individual's perspective, rather than focusing on what a prosecutor or enforcement agency's ultimate decision may be. Title VI of the Civil Rights Act prohibits discrimination on the basis of race and national origin, among other things, by recipients of federal funds. The law covers language access in such programs, and long-established federal guidance requires the development of language access plans for government service providers. Again, a key notion is ability to participate and utilize a program. LEP guidance standard is intended to be flexible, considers the number of people with limited English proficiency to encounter the program, how these limitations affect their participation, the resources available to the agency, and the size and scope of the program. Generally, guidance requires a mixture of languages and written materials and the offering of translational services for oral and other communications. Again, it's not focused on the intentionality of exclusion, but rather the individual's interaction with the program. And it looks at various points of interaction, not just the ultimate outcome of the experience. These laws, the ADA and Title VI, may provide both conceptual basis for improvement, as well as litigation risk to motivate changes. As such, they're worthy of further exploration by advocates to press for change. Now, a note of caution. The Supreme Court's jurisprudence casts great doubt on the use of racially expressive remedial interventions to overcome systemic racism in government structures. The tension between addressing disparate impact and the corresponding intentional discrimination against those who benefit from the disparities will gain more favor before this version of the court. Justice Scalia's concurrence in the case of Ricci versus DeStefano will probably become the law of the land, placing state and local governments in a difficult bind when they see the disparities caused by their programs and seek to remedy disparate impacts more intentionally. Ricci was the case in which the city of New Haven found itself exposed to claims of reverse discrimination by white officers when it sought to remedy the disparate impact on the promotion of Black police officers caused by a standardized exam. Oral argument in the recent Voting Rights Act case, Brinovich versus DNC, highlights these tensions again and right now. A majority of the court seems poised to adopt a neutral time, place, manner standard that focuses on generic application of laws, not just the individual's experience or the real world impact, especially in the communities the Voting Rights Act was designed to protect. From a constitutional standpoint, the pathway forward requires thoughtful approaches to interventions. The leeway that prosecutors are generally given and the discretion they are allowed to exercise may be an important buttress, but we've seen cracks in that armor as well. The Supreme Court seems to be fine with prosecutorial discretion as long as it's used in the right way. I want to take the time that's remaining to move towards interventions. We need to intervene to disrupt the bias and dismantle the systemic racism. From my vantage, there's not a singular solution. What's required is a combination of different approaches, policies, and systems changes, an openness to make major changes and then adjustments over time. Creativity, patience, and perseverance. You know, 3 things that government is well known for. What comes next are a series of concepts and suggestions, many of which are utilized by certain enforcement agencies right now, but it's not happening on the scope and scale that's needed. We noted earlier in the talk about the problem of the pipeline and the disparate inputs caused by who is complaining and bringing their concerns to the attention of the offices. This requires a determined strategy to overcome. Dedicated resources to outreach and education are an important step to disrupt this issue. Offices need staff to go out in the community and engage directly with consumers, tenants, and workers. Attorney General Healy made this a high priority for her team in 2015, hiring Marconi Almeida Barros as the head of the Community Engagement Division. And over these past 6 years, his team, which remains relatively small, has participated in hundreds of events reaching tens of thousands of people. In 2019, they hosted 300 plus events and trainings and served more than 15,000 people. We can find numerous other examples of this proactive engagement, as there's increasing recognition of the need to devote resources to connection. The New York City Commission on Human Rights, for example, has a team dedicated to outreach and spends considerable portions of its budget each year on outreach and marketing. In fact, one of PRP's current fellows is in the process of helping to develop advertisements to place in bus shelters with QR codes in order to direct individuals right to the Commission's website. Change also requires a shift in mentality and approach overall. Adding a few people to one group to handle community outreach is a start, but not enough. Strategies need to include a whole of office or whole of government mindset in order to be fully successful. To get more specific about it, enforcement agencies need to prioritize the skill development among staff that makes relationship development and partnership engagement at the forefront of the work. For too long, the roles have been too compartmentalized. When enforcement agencies consider annual reviews, professional development plans, and promotion, community engagement needs to be prominent in how they think about the strength of their staff. Those who can develop these relationships and find means to develop work that is community connected and informed should be prioritized and valued. They need to help staff develop their skills in these areas as well. Written briefs may go through 3 reviewers before they're filed. What about outreach presentations? There must be a recognition in what skills and ability are valued across staff, and changes are needed to drive efforts outward. We live in a digital society where consumer purchases products, food, and services online, and workers deliver products and services through applications. Government agencies must meet this reality. Certainly, we've seen a transformation in the use of online complaint portals and other means to garner attention and drive enforcement through online petitions and the like. But enforcement agencies need a digital architecture to match the residents they serve and better meet everyone where they are. At PRP, our team has utilized Craigslist, Facebook, and other platforms to post advertisements seeking information from workers and tenants. Even with a relatively small footprint and a modest budget, we've received robust responses, leading to the development of case pitches, amicus brief support, digital narratives, and much more content. People's stories and experiences are out there to be found. More government offices need to invest to find those stories. In many circumstances, there's actually no need to wait for complaints to come in the door, especially if they're less likely to come in at all. Instead, there's an opportunity to find methods of proactive engagement. Some agencies have an easy opportunity to take steps, sometimes with an automated or prescribed regularity, to take action before a complaint is lodged. The example of street lamps in Seattle is a great place to start. Several years ago, there had been some incidents of violence concentrated in the area of Southeast Seattle. The mayor went on a tour of the area and noticed that many of the streetlights were out. In fact, 80 of them in a concentrated area. She wondered how that could be. It turned out that the repair of streetlights depended on a complaint from residents. For a light bulb to be replaced, they needed to hear from someone in the neighborhood, and they weren't. So they decided to change their approach and move to a rather simple solution: proactive streetlight replacement. The bulbs have an expected life. Every 18 months or so, they replace the bulbs, whether they needed to or not, irrespective of whether they burned out. Simple, proactive, sensible. In the context of housing conditions, a number of cities have sought to implement more strategic enforcement efforts. The city of Los Angeles, more than 20 years ago, began a system of periodic and regular inspections of rental properties, which resulted in more than 1 million violations found over about a 10-year period. Some cities have tried requiring licensing or proactive inspection when tenancies turn over. In Sacramento, for example, landlords are subject to inspection for the first time a unit turns over, and then can self-certify the next change of a tenancy if no violations are found. The notion is to decouple enforcement from complaints. Strategic and regular inspection, though, can require an increased investment in resources. For example, the City of Philadelphia Code Enforcement Unit said that it would need to increase the number of inspectors by 400% to be able to engage in regular proactive enforcement. Mindset shifts also require different means of operation. Disruption can occur if power is shared, especially with those not in power or from marginalized groups. If enforcement choices are made accessible and available to community advocates, a new means of driving the work forward is developed. Some have referred to these models as co-enforcement, others refer to them as public-private partnerships. At their core, they are about embedding outsiders into the inside of enforcement frameworks and eliminating unnecessary artifices that have shielded decision makers from true accountability. For example, late last year, the Los Angeles County Board of Supervisors approved a program that called for the formation of public health councils. The program is focused on the safety of workers during the pandemic. Workers, especially those in hard-hit industries, voluntarily participate in the program by attending trainings that teach them about the county's public health orders. Seattle's Office of Labor Standards has a domestic worker standard board, which helps to advise on issues relating to some of the most vulnerable and marginalized and rarely heard from workers. Given that many of these workers live in homes where they work, they're often quite reluctant to come forward. The Standard Board has a robust agenda that's focused on access to protections. Key components of these public-private partnerships require integration at a few levels of the work. It demands visibility and conversation about prioritization and the ability to track progress against those priorities over time. This is about visibility, conversation, and information sharing. Some of this could be informal, but other pieces need to be structured, whether that's through funding, grant making, or honoring public commitments. Some techniques may be able to reduce or eliminate at least some racial bias in the decision-making process. Increasingly, employers are using techniques such as anonymizing applicant names as well as the names of their schools when reviewing resumes. San Francisco District Attorney Chesa Boudin is moving to remove all race information from underlying documents to reduce bias when making charging decisions. Training and compliance guidance can also have a priming effect for the review, which may interrupt bias. Recall the Harvard-based study of response to email inquiries regarding voter identification laws. I just want to conclude with a brief mention about equity analyses. One is a notion that I borrow from my colleague Krupa Desai called an equity pause. In fact, our team just participated in one before this talk. The second I'll call an equity audit. Pacing and equity considerations go hand in hand. The press to move quickly, to have an answer right away, to move things off one's desk are forces against equity. That's where the pause comes into play. We need to stop and consider our actions. We need to disrupt the perpetuation of the same decisions over and over again. So we need to create space for this thinking and an architecture for doing so. The Government Alliance for Race and Equity, or GARE, has developed a toolkit for government agencies interested in putting racial justice at the center of their work. Renowned psychology expert Jennifer Eberhardt has highlighted several examples where slowing pacing down has helped to eliminate bias in reporting. The social media platform Nextdoor is a community forum which found itself perpetuating race discrimination by allowing profiling through reports of suspicious activity. So Nextdoor worked with Dr. Eberhardt to combat this problem by adding what she calls friction. They did this by adding a checklist with 3 items to slow down reporting. And by using this strategy, by simply slowing people down, Nextdoor was able to curb racial profiling. Finally, my survey of government partners revealed that none of them conduct a rigorous review of the impact of their enforcement work. They don't meaningfully examine who's affected by how much and in what ways, and they don't evaluate whether choices made prevent more violations or impact more workers. Sustained and meaningful, deep analysis is not currently considered central to the work. It must be. Digging into the data allows for more proactive interventions as new and different disparities are revealed. It enables changes to the process to be studied, and it assures accountability. My hope today is to help advance the conversation in this space. I do not believe an end to the complaint system is in the offing anytime soon, but we can all demand that agencies and programs implement other complementary and disruptive strategies to reduce bias and drive the enforcement architecture of our government institutions towards equity. In fact, we must do so. And with that, thank you all for being here and be happy to take some questions.
John, I have a question, if I may weigh in. I don't see any others in the Q&A function. Lissy, do you have any? Let me start with what you may take as a provocative question, but it was occurring to me, amidst all of the positives that you very persuasively lay out, in favor of moving away from the complaint-based system, I found myself asking, why did that system develop in the first place? And are there any possible positives to it when compared to the alternatives? And I don't know the history of this, so I wonder if you could talk more about it, but it occurs to me that one of the dangers of the alternatives is that you do tend to rely on sort of generally expanding government, panels and commissions and standing boards and things, routinized responses like the light bulb thing. That's a small example, but if you take seriously the problem that government can't do everything that people need all the time, there is this question of interest group advocacy, and maybe there is something to be said for letting the individual squeaky wheel get the grease, as in regard to certain types of problems. And I don't mean to downplay the inequities in those systems, but I wonder if you think in some arenas there might be something to be said for maintaining that sort of episodic, individualized model.
Thanks for that question. I think there's definitely a role for this type of interface to continue to be a part of the work that government functions and offices have. To me, the question is what role do they play, and in what ways is it, sort of how much emphasis is it given? In what ways is this one input among many, as opposed to sort of a more regular driver of enforcement or other decision-making processes? So I think that it's right to say that that is an important part of information gathering. The question is how do we take steps to remedy disparities and discrimination that arise from so heavily relying on these processes?
There's a couple of other questions, so let's follow up on this in the next couple of days. I was just thinking that, to my mind, the criminal justice system relies on individualized complaint mechanisms, and that's probably generally a good thing, although it also has its obvious drawbacks, but there are some advantages there. But I see there's some other questions, so let me let others weigh in, and maybe we can follow up another time. Thank you.
John, can you see these questions, or do you want me to read them?
Yeah, I can see there was a question about how the pandemic has sort of affected digital outreach and connection, and I think I've definitely heard from our government partners and from former colleagues in the Mass AG's office that it's required everyone to think differently about delivery of service and connection. And I think that there have been some opportunities that have lent themselves well to do more outreach, but it's also, I think, very hard, and particularly for communities of color, sort of reaching the communities that we want these offices to reach better. There is a benefit to kind of a range of approaches. And I think improving the digital outreach is going to be a piece of it, but physical presence and connection to, I think, trusted partners in these communities is really crucial as well.
There's a question in the chat that says, might there be a way to retool the current system and incentivize a collective complaint-based model rather than an individual model?
Well, I think that there needs to be an examination of a variety of different models and approaches, and sort of thinking about what's the right what decisions and where could be evaluated in different ways, and whether that's about sort of looking for cumulative complaints or trying to aggregate information across different platforms, whether that's sharing across governments. Those are all the types of things that I think could be effective. Sort of the power of the data and information could be particularly important, especially when complemented with some of these other strategies that I think really drive connection and drive understanding. Because I think that that's there are a couple of things going on. It is about the input of the information, but it's also about deepening this information as well.
There's a question in the Q&A from an anonymous attendee, and I have to confess, I'm not exactly sure of what the question is. So whoever wrote that, if you would either raise your hand so we could unmute you, or if you could clarify the question, we'll pose it to John. We have a question in the chat about, do you think this is why and how the Karen model was developed or utilized?
I'm not sure which one this is referring to. Sorry.
Does Sharon, do you want to be unmuted to ask this question? Okay. Ask your question.
So I'm not sure if you're familiar with people who are called Karens, first of all.
I know what you're saying. Yeah.
Okay. So I think that, because for so many centuries, they know that if they complain, that something will be done.
Yeah.
Which is why, they feel so free to just go ahead and complain about anything or everything, and something is done, and then the person where this false accusation has been accused of is not even heard, basically.
Yeah. I thank you for jumping on and making that point, because I think that that's a really powerful point. And I think yes, there's a lot of entitlement, right, or a sense that people will get an outcome that they're demanding or asking, and will push harder as a result of race and privilege, and that it operates as pressure points kind of in both directions, with sort of not enough information or advocacy in one direction and too much in others. So I think that's an excellent point and seems right on to me.
John, I want to ask, in your work across the United States, are you seeing any movement toward changing the complaint-based model?
I think what we're seeing is some of the strategies that I mentioned towards the end, right, is sort of a amplification and an effort to rely on partnerships, shared power, or other methodologies. And that's certainly central to the work that we're doing at Public Rights Project, is to really try to push our government partners to think expansively and to sort of see complaints as a beginning point, but just just the beginning of an array of information that they should be gathering, and a means of beginning conversations with community partners.
Thank you. I think that answers your question, Heather, unless you have something you'd like to add, which there was a question about whether heightened awareness about racial equity is really triggering or inspiring an opportune moment to have the conversations about a different method of enforcement. So I think you've shared response.
Yeah, and I agree with Heather that given the connection to elected officials, we're not going to see, I think, a removal. And and again, I think this is the point that Dan raised, and I was trying to make too, is that there are definitely benefits to pathways that create responsiveness. I think we just need to have a recognition and an honest dialogue about the ways in which over-reliance on complaints perpetuates systemic racism, and the need to be really aggressive about finding other pathways and means to combat it.
Well, it's now 5:01, and on behalf of all of us at the Rappaport Center, John, I want to say thank you so much. This was really illuminating, really interesting. Seems like you have a lot of work ahead of you if you want to marshal change and try and create really a reckoning of a new model of enforcement across the country. So thank you for sharing this with us. It was really a learning experience. So we're glad to have you with us at the Rappaport Center. We look forward to getting to spend more time with you this week. Thank you, everyone. I hope to see you next Monday at our education program.
Bye. Thanks everybody for coming.